Competition for talent in wealth management is fierce. To break it all down for me, I'm joined by Jeffrey Csercsevits from Fisher Phillips to learn more. Jeffrey, thanks so much for joining me.
Thank you so much for having me.
So let's start high level a little bit and talk about some of the employment and trade secret challenges that RIAs are running into most often today.
Sure, I think first and foremost in today's environment, one of the biggest issues is succession planning. We have an aging workforce across all industries, but especially in the financial services space. We have advisors who are in the near future going to be retiring, and a large amount of them. So firms are tasked with how are we going to replace them? How are we going to handle the succession? How are we going to ease that transition for clients who are so accustomed to dealing with their primary advisor who is now going to be retiring, and how are we going to find them a suitable replacement to continue that relationship into the future? And so a number of challenges that do arise in that setting. First off, the firm has to find the right replacement. They need to initially have that talent that they can introduce to those clients to ensure that the clients are enjoying the same level of service, professionalism, and expertise that they've enjoyed for so long in order to retain those assets, to retain those client relationships. Second, I think a major issue that firms need to be mindful of is the advisor inheriting the retiring advisor's assets, accounts. They automatically have a massive increase in the amount of assets under management, client relationships. All of a sudden, they become much more marketable to the competition. And so for firms, they want to ensure that we're not simply handing these clients who have been with us for years to an advisor who's going to turn around, market those assets, and take a very nice lucrative deal at another firm, and ultimately take those assets away from the firm. Second, I think a big issue, and this is nothing novel, this is something that we've been talking about forever, it's the protection of confidential information and trade secrets. And certainly a big issue today is where's that information? How are we protecting it? Where is it being stored? And with the advancements in business, the advancements in technology, advisors and employees generally are using information in so many new and unique ways, with new apps and platforms being introduced on such a frequent basis. It's such a challenge for employers, especially in the financial services space, to keep track of this. Where's our information? Not only from a standpoint of we want to protect our information from the competition, but also in this particular space, they're dealing with highly confidential client information that you don't want to be disclosed. You do not want to get out into the public, into the nefarious hands of those who might do something horrible with it. And so for many employers in the financial services space, a couple things that they're considering are, how do we inventory our information? How do we know exactly what we have? What policies do we have in place to ensure that our employees are very aware of what we expect of them, what they can do with this information, what they cannot, when it's appropriate to take it off the platform, say for example to a client meeting where you want to have a hard copy document, when it's acceptable to place it onto a personal device and under what circumstances. So those are two of the big issues that we're seeing today.
Oh, data, it's still very much a dirty four-letter word in our industry, I will say. So another question for you though, what are some practical considerations for when RIAs are looking to hire advisors from the competition?
I think it really comes down to three things. First and foremost, know the contract. When a recruit is coming from a prior firm, they often will have some sort of employment agreement or restrictive covenant agreement. And it's very important that the hiring firm who's considering this recruit really understand what those contractual obligations are. Often folks will use the term non-compete to describe any sort of post-employment restriction. But that term non-compete has a specific definition. It really does mean one thing. Sometimes advisors will not have a pure non-compete. They might have an obligation or a restriction that purports to prevent them from soliciting clients to bring them to the new firm, or from servicing clients at the new firm or accepting business at the new firm. So the hiring firm really needs to be aware of what those restrictions are in advance of the hire. We often encourage firms to retain firms such as mine to consult with legal counsel so that they can really understand what the restraints are, to take a look at whether or not the restraints are actually enforceable against that individual employee, given the terms of the restraint, the length of the restraint, as well as other factors such as where that employee resides and what governing law is applicable to the contract. So we really encourage firms to really know the contract out of the gate. The second thing that's important is to know the competition, to really have a firm understanding of what firm you are hiring from. If this is a firm that historically is very litigious, if there's a high likelihood that this recruit, upon joining your firm, is going to see litigation, you really need to be prepared for that. And that's often a consideration that they give. Is this worth the risk? Is the amount of assets, the business potential, is it worth the risk of our firm getting sued, the advisor getting sued, having clients potentially not be able to come over, having this individual who's trying to transition their business being tied up in litigation for the next 2 years. And I think the third thing is to really know your team. What's very important in the transition process is this is a very complicated transition. It involves the touch from so many different departments within the hiring firm. So in addition to, by way of example, the local business leadership who maybe has led the charge on the recruitment, you want to make sure that you have other channels within the organization who are aligned. For example, compliance, marketing, legal, just to make sure everybody's on the same page and it's going to be a smoother transition for the advisor, not only from a litigation standpoint, but in a perfect world, that's also going to make the overall transition and addition to the team much smoother and much better for the long term.
So let's flip the coin then. And what would you say would be a few practical considerations for RIAs when they lose an advisor to the competition?
I will rinse and repeat and say, once again, really know the contract. First off, understand what contractual obligations your former advisor had. Understand if they had a non-compete versus a non-solicit or a non-acceptance provision. Understand what those restrictions really say. So I would say, first off, again, know your contracts. Second, I think a practical step is often, we were talking about data earlier, a second step is to do a forensic analysis. By way of example, taking a look at the departing employees' forensic activity in the sense of looking at their prior emails for the weeks, days leading up to the transition. Were they sending emails to their personal email account? Were they trying to use a thumb drive or anything along those lines that show they were trying to take steps to remove information and take it with them to the new employer? Third, I would also say that it's important to have a transition plan in place. I view it as insurance. Obviously, we hope we never need it, but if we do, we're glad we have it. So we often encourage firms to take a look at what plan, if any, they have in place for the unexpected transition of an advisor, because it happens very, very quickly. Minutes matter. If someone resigns on a Friday, they're out the door, they're contacting clients. If you are scrambling, you are losing time in that race to retain business. So it's often important for firms to have a plan in place, to review it periodically to ensure that if, when that situation arises, they are ready and they're going to remain competitive to retain the business of those assets.
And this comes as no surprise probably to anyone that the RIA industry is seeing a lot of aggregation and M&A activity right now. What should firms and advisors have top of mind when considering these transactions from an employment law perspective?
I think a big factor is often with these deals, they're often driven by, for example, from the selling side, they're often driven by the senior leadership within the team, the firm, the senior advisors. Who often gets neglected in these deals are the more junior advisors who are essentially along for the ride and being directed, we are moving, we are making a change, you're coming with us. That can often lead to a lot of situations where upon the completion of the deal, maybe a year later, that junior advisor takes a look and says, I was not involved in this, I did not really get any sort of adequate consideration, compensation, whatever the case might be, this is not what's best for my clients, I'm going to look elsewhere. And then all of a sudden they're in that situation where they start to look elsewhere and they make that transition out. Where that's problematic is the purchasing firm paid for those assets a year earlier, and now all of a sudden the value of the deal is simply not what it was a year earlier because the goal was on the senior advisors really making the decisions and not fully paying attention to the junior advisors. And so certain things can be implemented to try to ensure that the junior advisors on the team are treated well. They're part of that conversation. Maybe they're given equity, maybe they're given additional restrictions on their ability to leave within a year and take that business. But I think it's just that idea of keeping an eye on everything you're acquiring and not just perhaps the large producers at the top who are making the decisions. Another aspect of that as well is taking a look at it from the advisor side, the employee side, as the seller. Thinking about the deal, often we see situations in so many aspects of life where we have this great idea, we're going to get together, things are going to be great, nothing's going to go wrong, and sometimes it just doesn't work out. And so I think it's often important for the selling firm at any level within that organization to really think about what will this look like if things don't go well? What does it look like 2 years from now? Would I have the ability to leave? What sort of financial impact would it have if I left, if I went somewhere else? Would I be able to take my clients? And really just to factor that in and think about a plan B, just in case this wonderful marriage does not quite work out as we anticipate.
Well, to your point, like you said, I think it's all about having a very robust plan. So Jeffrey, I certainly appreciate your perspective and insights. Thanks for joining me.
Thank you so much for having me. I appreciate it.
Absolutely. For Wealth Management, I'm Shannon Rossick.